This section got broken up from the last section. I thought we would have two sections for this chapter, but it turns out we're going to have three. And this slide is the tail end of the last uh, voiceover slide selection. And we're talking about children as witnesses. And we mentioned at the end of the last one that the small children are often not considered competent. Ohio has the good example of under 10 years of age, but many children are considered competent. And one of the cases that we have in the book is one that I'd like to call your attention to that we'll take a brief look at here, but you certainly should read it carefully. And it's the case of State v. Wells on page 857. And in State v. Wells, it was a case where Mr. Wells had been convicted of the crime of gross sexual imposition of a child and one count of rape. And the child, who was 5 years of age, was allowed to testify against him. She, as you might note, is well under the age of 10, which is the Ohio cutoff, but still there's a possibility that she might have been considered competent as a witness. And so the defendant alleged that the trial court judge abused his discretion by finding the child of 5 years of age as competent to testify against the defendant, Mr. Wells. And in the book itself, it says basically every person is competent as a witness except for children under 10 years of age. That's the Ohio statute. Under 10 years of age who appear incapable of receiving an impression, just impressions of the facts and transactions respecting which they are examined or going to testify. So they look at the four elements of competency. They talk about a 5-factor test there on page 857, but it's basically what we've talked about always: oath, perception, recollection, and the ability to communicate. And we've noted that children of tender years do not have to take an oath, but they have to be examined as to their ability to tell the truth. And so in this particular case, the defendant thinks that the child did not understand the difference between truth and falsity and of the duty to only tell the truth. And so in this case, the child, the 5-year-old child, initially the judge determined that after she initially demonstrated that she didn't understand the concepts of truth and falsity, and under further questioning called voir dire here, this issue was not sufficient to demonstrate that she did understand the concept of truthfulness, and that she understood the duty to tell the truth. And so the general rule in such a case is that a deficiency in the child's competency can be cured if the child's subsequent testimony demonstrates that she knew the truth and falsity and the duty to tell the truth. But in this particular case, she was unsure of the difference between truth and falsity, and had so stated during the questioning by the judge and the attorneys for the case. And so in this particular case, the defendant's convictions for sexual activity against the child was reversed because they did not prove that the child was competent. Now, upon a retrial, if they're able to ask the child the right questions and get the right answers, that she does understand the difference between truth and falsity, and they may use some examples for that. And if she's able to clearly communicate that she understands the clear importance of the duty to tell the truth, on a retrial, she might be able to give substantially the same testimony that she already gave. The problem was in this case is that the trial court did not sufficiently either allow inquiry or conduct the inquiry itself to prove that she had the substitute for the oath, that is, the understanding of truth and falsity and the understanding of a duty to tell only the truth. And the concurring opinion here indicated that the prosecutor asked Miss TV questions about what is right and not right, but never linked the two concepts to truth or falsity. And so that was the vice that the concurring opinion felt. And so in this particular case, since the child was ruled incompetent upon appeal, they'll send it back. And on a retrial, the judge and the parties to the case, especially the prosecution, may be able to show that young TV is competent as a witness, even though she's under the age of 10. 5 is a fairly young age to find somebody capable of talking as a witness in court. So there may be some problems on a retrial with this particular case. Okay, husband and wife. Let's move on to that one here. And the uh, the old rule years and years and centuries ago was that once a man and a woman married one another, and I guess today husband and husband or wife and wife, but back then, if the two married, they were not allowed to testify against each other or for one another in support or against the individual. Part of this came from old law and concepts that when a man and a woman married, they became one in the legal sense, and the wife's existence, separate legal existence, was subsumed into the husband's. And that was where matters stood for quite a while, but gradually it its absurdity became apparent, and the thought was that both a defendant would lie because he had an interest in the case or she had an interest in the case, and a spouse would also lie if she were deemed to be the witness who was typically a spouse would not normally be permitted to testify for or against that person. However, as humans became a little more enlightened, states in this nation have repealed all laws regarding the lack of competency of spouses. When we talk about lack of competency, we're not talking about a privilege that might exist. We're talking about the 4 elements of competency and the legal concept that a spouse can testify for or against another spouse. It's only the question of privilege whether a witness spouse can refuse to testify, or in the case of confidential communication privileges, where both the defendant spouse and the witness spouse could prevent the witness spouse from testifying. The witness spouse could refuse to testify if it were confidential in nature, and if it were confidential in nature, if the witness spouse wanted to testify, the defendant spouse could prevent the witness spouse from testifying. So there's not a lack of competency per se. There's an element of privilege with husband and wife, but where the other spouse may not be able to testify against the defendant spouse. So marital privileges are a little different than competency. So to recap this slide, originally spouses were not competent to testify for or against each other, partly because of the unity of a man and woman as one legal entity upon marriage, and that at some point the persons with interest in cases, like a defendant, could testify in his or her behalf, and then it became that spouses who were witnesses might be allowed to testify, providing there's no marital privilege that might exist. And we have a whole chapter on privileges in which this will come up again. So for now, husband and wife are generally competent witnesses for the 4 elements of competency, but there may be other rules of evidence that prevent them from testifying against one another. Generally, they're allowed to testify on behalf of another. Conviction of crime. It used to be that anybody who'd been convicted of a crime, especially a felony, and had not been executed in merry old England, was considered incompetent, because people who were criminals just absolutely wouldn't tell the truth. There was no chance that the individuals who'd been convicted of crimes would tell the truth. And it didn't have to be a crime of moral turpitude, although larceny or theft would be one of those. But if a person had been convicted of a crime, one often was not considered competent as a witness, and that was especially a problem if one were the defendant and could not testify in his or her own defense. However, modern rules say that proof of a crime may be used to impeach a witness who's testified during direct examination. Let's assume the defendant takes the witness stand and testifies in his or her own behalf. The witness can be asked on cross-examination generally, have you ever been convicted of a crime that involved dishonesty or a felony? And either one of those questions could be asked. Is it a felony? Have you been convicted? Or was it a crime of dishonesty of which you've been convicted? And those have the effect of impeaching somebody. Felony crimes, we somehow have got the idea that the individual who's been convicted of some felony would not be a truthful person. And we clearly have, and probably with good reason, have an idea that somebody's convicted of a crime of dishonesty like embezzlement or larceny or some sort of theft or robbery involving dishonesty might not tell the truth because their life indicates that they have a dishonest streak. So modern rule here is, of course, that people with felony convictions may testify, but the credibility can be used on impeachment by the opposing side. So the prosecutor could ask somebody who's a defendant who's taken the witness stand, Mr. Jones, have you ever been convicted of a felony within the last 10 years? Yes, I have. And what was that? And Mr. Jones may say robbery, burglary, or something like that. And so that is thought to impeach the defendant's credibility. So whatever the defendant said on direct examination when questioned by his or her attorney can be tested by asking the prosecutor asking about criminal convictions, especially ones involving felonies and dishonesty. So conviction of a crime is not an absolute disqualifier at all in the modern world, but it may impact credibility. Religious belief. The old idea was that if you didn't have a belief in a supreme being, you could not be considered competent as a witness. Now, this was not part of the four elements of competency, but it was a separate issue in its entirety. The story is that if you didn't have any worry about meeting your maker at some point in life, that there would be no real reason to be a truthful person while on earth. And I guess that works out pretty well for those that have faith. And in legal theory, those that had no faith didn't have to answer to any supreme being upon leaving this earth. So the old idea was you had to have a belief in God or you couldn't be a witness. In federal courts, religious belief or lack of belief is not used anymore, or in state courts to test credibility, to enhance it, or to prevent somebody from testifying at all, whether it's a witness or it's the defendant. So real strong general rule here, of course, is that religious belief or lack of it, or belief in some what we might consider an oddball faith or oddball religion, is not something that can be mentioned in court to affect credibility. So religious belief, while it once was a disqualifier if one did not have it, this is no longer the case in present time. So we move on to a couple other people as witnesses, judge, and perhaps jurors and attorneys. But federal courts by federal rules say that the sitting judge who's hearing the case is not considered competent as a witness. He or she may meet the four elements of competency, but you're not going to be a witness if you're a federal judge sitting in that particular case. So the judges simply are not considered competent even though they meet the four elements. Now there is a thought here. What if a federal judge was in a bank and a bank robber came through and the mask slipped and the judge recognized the robber and later is called by the prosecution to testify in the bank robber's case? No problem. The judge can testify because the judge is not sitting in that case and hearing that case. So the judge is perfectly competent as a witness to explain what he or she saw in the bank and how he or she recognized the defendant as being the perpetrator. But if the judge were sitting in that case, the judge could not testify. So I'm not sure that there's any state that would allow a judge who's actually hearing a case, presiding over a case, would allow that judge to testify in that case. If the judge has enough knowledge in which he or she should be a witness, the judge simply should recuse himself or herself and not even bring this issue up. In many states who've adopted the federal rules, simply the state judge is incompetent in a case in which the judge is presiding. Obviously, if you're the prosecuting attorney and the judge said something that didn't help your case, would you be willing to do something that would show the judge might not be a truthful person or might have been mistaken without angering the judge? If the judge sitting in the trial, the judge is clearly likely to be torqued at the prosecutor, and the same would go for the defense attorney. If the defense attorney cross-examined the judge and questioned the judge's either judgment or competency or credibility or ability to have perceived or remembered, that would certainly make the judge lose impartiality, or certainly would challenge most judges. So that's the basic reason why a judge simply should never even consider hearing a case where he or she could be a fact witness. Competency of jurors. Federal rules of evidence do not permit a sitting juror to be a witness. So if the juror has enough knowledge to be a witness, that juror should be a witness and not a juror. And often this comes out when they question the jurors. In federal courts, the judges question the jurors as to their ability to be impartial. In state courts, many of the attorneys do the questioning and not the judge who's sitting in the case. But federal rules do not allow a sitting juror to be a witness. If if it shows up the potential juror might be a witness in the case, the juror should be excused. And again, many states follow similar deliberations because that one juror during the deliberations could have an undue influence. He or she has some special knowledge, and that would not be the case. Most witnesses would be testifying in open court and then go home, and the jurors would retire to the jury room. If you allowed a juror to be a witness, then one of the witnesses retires with the jury as part of the jury, and that is not considered appropriate. So uh, even after a jury has rendered its decision, generally jurors are not competent to testify about the decision, about the deliberation, or related issues. And most states follow this policy. So uh, the idea is that you cannot impeach the verdict of a jury as a general rule. There are some exceptions that's way beyond the scope of this course, but the general rule, of course, is that once jurors, be they state or federal, have made a decision, then that decision is not to be called into question by uh, trying to show that the jurors were doing something other than what they should do. The juror may testify in a later proceeding concerning extraneous different types of things that might be brought to bear on it. Years and years ago, there was a case involving a labor leader named James Hoffa. He's been in the news a little bit lately, and Mr. Hoffa apparently had tried to influence some of the jurors on the sitting on the jury of a particular case involving Mr. Hoffa as a defendant, criminal defendant. And they were trying to offer one of the jurors who had a husband who was a police officer, trying to get him a promotion. She didn't want money, she wanted a promotion supposedly for her husband. And later on, in a second trial, the fact that the jury was there was efforts made to influence the jury, that did come out, but that is a kind of a fairly unique case that a juror who was involved in that case with Mr. Hoffa was allowed to testify at a subsequent hearing, not the very hearing at which the prosecutor and the defense attorney were making the contest with Mr. Hoffa. This was about a second prosecution called jury tampering. So courts generally want to protect jurors from extensive inquiry by the losing parties, and when juries have been discharged, they may talk to the losing party, they may talk to the prosecutor, and they may talk to the news media. And once they're discharged, they're free to talk to anybody or to no one. It's up to the juror itself. But a jury as a witness in a criminal proceeding, in the very case in which that jury is deliberating or will deliberate, should not be allowed to serve as a juror. So a little summary here for this chapter 8. We know that elements of competency, oath perception, recollection, and an ability to communicate. We know that the evidence must be competent, meaning it meets logical and legal relevancy tests, and we must have witnesses that meet the 4 elements of competency. Some potential witnesses may not testify, judges, jurors, and some other individuals, such as spouses, may be prevented from testifying under certain circumstances. So that concludes Chapter 8, dealing with competency of witnesses and competency of evidence.